Welcome to the first Foyle Island Learning event for 2024. I'm very pleased to see everybody. Got a nice turnout for this one. The subject is sudden onset, the defence. And I noticed we've actually got quite a few people who have come in from outside of Ireland. So clearly it's a subject that's of wide interest. So delighted to have Deirdre Browne with us this afternoon. And I think that's all I need to say, Deirdre. So I'll pass over to you. I'll keep an eye on the waiting room, and anybody else who pops up, I'll let them in, of course.
Great.
Thank you.
Okay, good afternoon to all of you, and hello from a very blustery west of Ireland. Thank you for the introduction, Lawrence. My name is Deirdre Browne. I'm a barrister based here in Galway on the Western Seaboard and on the Western Circuit in Ireland in general practice here. And what I plan to do is to maybe talk to you, give a formal presentation for 20 to 25 minutes, following which, if anyone has any observations or contributions, that would be great. Similarly, if anybody has any questions, we take them at that stage. So what I'd like to do is, in teasing out the parameters of the defence, to explore maybe how the case law has evolved both in the UK and in this jurisdiction, because I think it's through looking at the cases and how they have interpreted the facts that the parameters of the defence and its potential value in defending road traffic accidents becomes clear. So the sudden onset defence, the clue is in the name. It will typically arise in a road traffic accident where prima facie the defendant is liable. So it will typically arise in a situation where a car will veer onto the wrong side of the road. It may veer off the road entirely, causing significant damage to persons or property. But the defendant will seek to avoid liability, arguing that the accident occurred not through any fault on the part of the defendant, but as a result of a medical condition. Now, through the cases, there's a theme. Certain medical conditions tend to recur. So you'll have cardiovascular or cerebrovascular events, such as heart attacks and strokes, possibly aneurysms. Another recurrent theme is a metabolic disorder, diabetes being probably the most common, leading to hypoglycemic episodes. Metabolic disorders leading to epileptic incidents, and more recently sleep apnea and sleep attacks. And in looking at the cases, really, I suppose the themes which emerge from the cases is the suddenness of the incapacity relied on by a defendant. Were there signs or symptoms that a defendant should have been alert to? Or did the driver, him or herself, contribute to or cause an increased likelihood of the incapacity? In Ireland, one of the earliest reported case, or the earliest two reported cases, both arose out of the same accident. The first is Kelly and Gilmore, and the second is Murray and Gilmore. And interestingly, while they both arose from the same accident, they both ended up in the Irish Supreme Court with different outcomes. That was typical, if one can sort of describe the typical in terms of facts, in that the plaintiffs in both the Kelly case and the Murray case were struck by a car which was being driven in Dublin city centre, and it veered onto the street, onto the wrong side of the road, accelerating probably for 70 or 80 yards, mounting a footpath and striking a number of pedestrians. Mr. Kelly, who was the plaintiff in the first case, Kelly and Gilmore, was standing outside a drapery shop and was thrown through the drapery shop window, suffering serious injury. And the High Court in Ireland awarded him what were very substantial damages for the late 60s, the sum of €7,200. However, the defence in Mr. Gilmore's case appealed to the Supreme Court, and the Supreme Court held by a 3-2 majority that the case should never have been allowed to go to the jury. Having considered the medical evidence in the case, the judges held, and there was a lot of medical evidence, that the defendant had been the victim of a sudden onset of unconsciousness. The medical evidence in that case established that Mr. Gilmore had suffered, who had a history, he was a 60-year-old man, he had a history of high blood pressure, but he'd never previously had any incidents of dizziness or fainting. The medical evidence established that because of a steep rise in blood pressure to the brain, he had a cardiovascular or a cerebrovascular event. The blood supply to the brain was effectively cut off with an immediate loss of consciousness. What was crucial in the Kelly case was that Mr. Gilmore was alive and well and in a position to give evidence. He gave evidence that he had had some awareness of a flickering, he described it, at which stage he reached for his glasses and then remembered nothing until he woke on the side of the road. Mr. Kelly, unfortunately, despite his solicitor being very quick off the mark and getting his case to the Supreme Court within 5 years, the accident happened in 1965, unfortunately didn't succeed. Miss Murray, her legal team were somewhat less expeditious, and her case took a while longer to come on for hearing, and it was the very same accident. And in that case, in the High Court, the case had been withdrawn from the jury on the basis that effectively the case had already been decided in Kelly and Gilmore. The crucial difference between the High Court in the Kelly case and the Murray case was that Mr. Gilmore was not alive by the time the Murray case came on for hearing. So the Supreme Court held that in those circumstances, the jury had no evidence, the jury had no direct or no compelling evidence from Mr. Gilmore. So it certainly was open to the jury to have found that the defence of sudden onset had not been made out. In other words, that the defence had not rebutted negligence as causing the accident and directed a retrial in the Murray case. So there was no substantial, it was very much the consideration in both of those cases, which for Irish readers of a certain vintage are interesting in that they describe a Dublin long since past with long recitations of eyewitness testimony from various bystanders. But they don't they're very fact-based and they don't go into matters of principle to any great extent. And the next reported decision from an Irish point of view that I was able to locate is a decision of Mr. Justice Lavin in O'Brien and Parker, and that was a circuit appeal. And in this particular case, again, the evidence in the case is strongly suggestive of a slam dunk case against the defendant. The defendant was driving, veered onto his incorrect side of the road, colliding with the plaintiff's vehicle and subsequently with two other parked vehicles. But in his defence, the defendant argued that he had suffered an attack of epilepsy without any prior indication or warning. And it appeared in that case, the argument was that in that case, that there had been no negligence on Mr. Parker's part. Now, the medical evidence in that case established that the defendant had not previously been treated for epilepsy but that on the particular day he developed and it became manifest that he had temporal lobe epilepsy. And his medical evidence was that this manifested itself out of the blue. Now, in that case, there was a significant concession by the defence. The defence conceded on the state of law, as had been articulated at the time, that in order to succeed in the defence of sudden onset or sudden illness, that the defendant had to essentially establish that he was suffering from a total loss of control. And in the case, both the judge and I think both counsel for the plaintiff and counsel for the defendant seemed to accept that the sudden onset defence in civil law was akin to automatism as it applies in criminal cases, where somebody is effectively rendered an automaton and incapable of exercising any control whatsoever. So the defence made a very important concession, as I say, that the illness in question, the illness had to render the defendant an automaton or to render him immediately unconscious without any voluntary control. And Lavin J relied on the existing British authority. The UK authority at the time was Roberts and Ramsbottom, and he found that in that particular case, the defendant had experienced some of the signs and symptoms and warnings of an epileptic episode while at home, and made the decision to drive despite these difficulties. And while he was driving, he experienced the difficulties some seconds before the accident occurred. So in that case, again, the defence did not succeed and the plaintiff prevailed. Now, as I say, the decision in that particular case is understandable given the parameters that everybody accepted were governing the issue at the time. And Lavin J, as I say, approved the principles decided in Roberts and Ramsbottom, and that transposed the criminal defence of automatism into civil law. And the dicta from the Roberts and Ramsbottom case that were articulated by Neil J were that a driver could escape liability if his actions at the relevant time were wholly beyond his control. The most obvious case being unconsciousness. If he retained some control, albeit imperfect control, and if his driving, judged objectively, was below the required standard, he remains liable. So at that stage, it was a very strict test, imposing almost strict liability, and the driving in question was to be judged by the standards of the reasonable driver. And before the matter came to be reconsidered in Ireland, which it did in 2005, the position in the UK moved on. So in the UK, you had a decision of the Court of Appeal in the case of Mansfield and Weetabix. Mansfield and Weetabix was a case which is reported in 1998. That was a case where a 38-ton truck belonging to Weetabix failed to take a sharp bend in the village of Upper Tean near Stoke-on-Trent in Staffordshire, and it crashed into the shop belonging to Mr. and Mrs. Mansfield, causing extensive property damage. In the Mansfield case, the driver of the car was a man named Mr. Tarleton, and Mr. Tarleton, it transpired, had malignant insulinoma, the result of which was that he, on the day in question, was in a hypoglycemic state. His brain was starved of glucose and he was unable to function properly. And that was what caused the accident. The trial judge at first instance found that it was unlikely that Mr. Tarleton had completely lost consciousness at any stage before the accident itself, but his ability to drive properly was impaired because of the hypoglycemia. In fact, there had been 2 incidents before the incident under consideration, and I think in one of them he had actually been stopped by the driver, Mr. Tarleton, had been stopped by the police, but Mr. Tarleton himself remembered absolutely nothing from about 1 p.m. until the accident, which was at about 3:40, 3:45. And the judge who dealt with the case noted that it was a peculiar condition in that Mr. Tarleton was impaired. He was unable to rationalise, he was unable to form judgments, but also his condition meant that he lacked insight. He wasn't aware of the fact that he was so impaired. And the judge felt that he was in a state where his brain could function sufficiently. He could manoeuvre around bends, he could decide where he was going, he could slow up and slow down and speed up appropriately. So the messages were going to his hands and his feet to drive the car. And at the first instance, the trial judge, in line with what had been the standard up to then, articulated an objective standard of care, and he looked at Mr. Tarleton's driving in terms of what would be expected of a reasonably experienced driver, and as he described it, sound in wind and limb. And at first instance, liability was imposed on the driver, and the status quo seemed to be maintained. However, the Court of Appeal reviewed the matter and considered that this was not the correct approach, that there was no reason in principle why a driver should not escape liability where the disabling event is not sudden, but it's gradual, provided that the driver is unaware of it. So the Court of Appeal moved towards a standard of care which took into account more subjective factors and took into account the condition of the driver. So the standard of care that they said was the appropriate one was that of a reasonably competent driver, unaware that he is or may be suffering from a condition that impairs his ability to drive. The Court of Appeal held to apply an objective standard in a way that doesn't take account of the driver's condition would be to impose strict liability. And that I suppose that dicta highlights that at the centre generally of negligence law is the question or the issue of fault, and that the issue of a driver being at fault is central, but and the Court of Appeal are putting it back. The difficulty, I suppose, with the type of standard articulated in Mansfield, and indeed it was referred to by the judges in that case, as indeed it was subsequently in Ireland, is that it's a difficult one for a judge. You have a badly injured plaintiff, injured through no fault of the plaintiff, but there is nobody to compensate the plaintiff in those circumstances. And that is the situation that presented itself in Ireland in a decision of Mr. Justice Clarke, who subsequently became our Chief Justice, sitting in the High Court. That was the case of Coonahan and Bus Áha Clia, Dublin Bus, and it's not Arthur Ebbs, I think it should be Arthur Ebbs. Mr. Ebbs was the bus driver. And the question of what were the appropriate principles to be applied in these situations came for consideration in Ireland before Mr. Justice Clarke. Now, in that case, it happened in an area of Dublin, which will be known to any of our Irish participants. 2 pedestrians were walking along the Stillorgan dual carriageway in Donnybrook, and they were very badly injured when a bus being driven by Mr. Ebbs crossed from the middle carriageway on the road and veered right across over the road, crossing a number of lanes, mounting the footpath and striking the plaintiffs. Now, the medical evidence before the court established that the driver suffered from what's called sick sinus syndrome. It's a condition that affects the rhythm of the heart, and it had led in Mr. Ebb's case, without any forewarning, to a complete blackout. The court was satisfied that Mr. Ebb's condition had not been symptomatic before the date of the accident, and there was no basis for suggesting that Mr. Ebbs himself or his employer, in this case Dublin Bus, ought to have been aware of the danger of Mr. Ebbs driving. So any contention that there was negligence on the basis of driving knowing that there was a risk would necessarily fail. And then the court had to go on and consider, well, was there negligence in the driving of the vehicle? And Mr. Justice Clarke reviewed the law. He referred to O'Brien and Parker. That was the Judge Lavin decision about the epilepsy. And he expressed a view that, in fact, the Mansfield test, the more subjective test, fitted more closely into the principles applicable to the establishment of liability for negligence in civil law than the test suggested in Roberts. And Mr. Justice Clarke was satisfied to adopt the test. Ultimately, he found it wasn't necessary, but he said that should the case go further, he was happy to adopt the test articulated by the Court of Appeal in Mansfield, and that the standard of care that a driver was obliged to show was that to be expected of a reasonably competent driver, unaware that he or she was or might be suffering from a condition that might have impaired his or her ability to drive. Now, on the facts of this particular case, the defendant would have succeeded even on the Roberts test, in that the evidence was that he suffered quite an immediate blackout, and there was a dispute about eyewitnesses thinking he had come to and tried to control the vehicle. But again, the court found even if he had, he was gone again very, very quickly. The Roberts test would have been met. In other words, it was an involuntary situation. But Mr. Justice Clarke did take the opportunity to articulate what he saw as being the appropriate test to be applied. And he took a quote from the UK, and he was quite clear in sort of putting it up as a policy matter, saying that the law as it stands requires compensation can only be obtained in an action for damages, and requires as a condition of the award of damages against the driver a finding of fault or negligence on his part. On the other hand, if no blame can be imputed to the driver, the action based on negligence must inevitably fail. And reluctantly and with a heavy heart, he said Clarke J dismissed the claim. And I think that that's certainly practicing at the circuit court level. That heavy heart will often lead judges. I know after I had spoken on this topic at a particular event in Ireland last summer, you know, a couple of people had experienced situations where judges, certainly at the circuit court level, were quite prepared to find some fault somewhere to ensure that innocent plaintiffs who were badly injured often in these accidents, were compensated. But again, Mr. Justice Clarke is quite clear in his judgment that such issues are matters for policy, and that it isn't the function of the courts to push out the parameters. If the action is based on negligence, the plaintiff has to establish fault. And if the
could I phone him back? Could I phone him back tomorrow? I'm just on the middle of a training CPD thing. If I could phone.
Fine. Hopefully he's phoned back. So that central to the issue of negligence is the question of fault, and where a defendant can establish that there was in fact no fault on the part of the driver, the defendant should succeed. An interesting case which is slightly off point, but its relevance is that it has been relied on elsewhere to row back on the type of Mansfield jurisprudence, is the case of Donage and Randall and UK Insurance Limited, reported in 2015. That was a case, it wasn't a road traffic accident, it was a case where a Mr. Vince, who was, as it transpired, an undiagnosed paranoid schizophrenic, was visiting his nephew and his nephew's wife, and ultimately, as a result of florid delusions, set himself on fire. And in the course of trying to prevent an incident, his nephew got very badly burnt. Mr. Vince himself didn't survive the incident. And ultimately, a case was taken against Mr. Vince's estate and his insurer. Now, in that case, the court seemed to move back to a much stricter liability situation, despite the fact that Mr. Vince was clearly acting under the impetus of these florid delusions, and his functioning does seem to have been very significantly impaired. The court found that the defendant, in such circumstances, can only escape liability for negligently caused injury if their mental illness entirely eliminates responsibility, thus articulating a strict approach to liability in tort of persons suffering from mental illness. So it seems to be automatism type language, maybe couched slightly differently, but it certainly is moving back towards a much stricter interpretation of what a defendant has to establish to succeed. In that case, the court in England went to great lengths to distinguish the case before them from the case of the driver who gets into the car mentally and physically fit and then has an unforeseen episode. And they tried to distinguish Mansfield, but it's very difficult to square the philosophy articulated in Mansfield and the Donage decision, in the sense that there was a much more significant consideration given to the subjective circumstances of Mr. Tarleton, the driver, in the Mansfield decision, whereas no such allowances seem to be made for Mr. Vince in the Donage decision. And really, I think the court elided the issue. It didn't address it head on. It simply distinguished it rather than dealing with the issue in Mansfield, which is whether what was the standard required. In Mansfield, it's very clearly articulated. It was the standard of a reasonable, unimpaired driver, unaware of the fact that he was suffering with his condition, whereas it's very difficult to see what, if any, allowance was made by the court in Donage. And as I say, the significance of it is that certainly in Singapore, it seems to have been relied on as a second line of authority, and to have moved away from the Mansfield standard of care to back towards a more strict liability, and it has been relied on, as I say, to impose a higher bar on a defendant in circumstances. The case in question, I don't have the reference, but it was a case of a driver suffering a stroke, but still retaining some use, I think, of the right side of his or her body. And as I say, drainage in that case was relied on to find for the plaintiff. A recent case, and I suppose it's more by way of illustration as to the type of situation in when a sudden onset defence might be advanced. It was a significant case in Ireland, Davy and Sligo County Council, and MDS Distribution Limited and Zakar. This was a case which came on before the High Court and the Court of Appeal in Ireland. And it's one where the sudden onset defence was there, possibly, but it didn't fall to be directly considered either in the High Court or in the Court of Appeal. What was interesting, I suppose, about this case was that I was conscious in reading it. I had been aware of the facts of the criminal trial. There, Mr. Zakar, the driver, first of all, the facts of the case were particularly nasty. It was an accident which occurred in Ireland on one of the main national highways in 2015. An articulated lorry veered off the road onto the hard shoulder, and there were county council workers carrying out maintenance works on the hard shoulder. There was one fatality and 2 of the workers were very badly injured, including the plaintiff in this case, Mr. Davy. As I say, the civil case had been preceded by a criminal prosecution of Mr. Zakar, the driver. The criminal case heard very, very detailed evidence from sleep experts, and both of them agreed that Mr. Zakar, the driver, was in fact suffering from severe obstructive sleep apnea, which could cause a sufferer to fall asleep without any warning or any sensation of drowsiness. And it was also accepted in the course of the criminal case that Mr. Zakar had no knowledge of having this condition prior to the accident. So in dealing with the criminal trial, the judge in that case felt he couldn't treat the case as being one where Mr. Zakar made a bad decision of creating a risk to the public, and found that he was not aware that he had the medical condition. So it's a Mansfield type of, obviously it's a criminal case. He was being charged with dangerous driving causing death. And the case was otherwise complicated by the fact that Mr. Zakar had set his tachograph at 88 kilometers per hour, where the speed limit is 80. So it was on that basis he was convicted of careless driving, causing serious injury or death. But in the High Court, it was just interesting because it's not clear to what extent the issue of sudden onset was argued at all. The High Court judge made very stringent findings of fact against the driver. The High Court found, as a matter of fact, the driver was aware he was feeling drowsy. He made a conscious decision to drive. He was aware he was at risk of falling asleep. I don't know to what extent the medical evidence which was available in the criminal case was aired or ventilated in the civil action. But certainly it was a very different set of facts, which seemed the conclusion of fact, and was very different. And the case, the main issue which was reported in the case was a row about liability between the lorry, the driver, and the Sligo County Council, with the lorry and the drivers seeking to argue that the County Council should have had better precautions in place. But as the type of case in which, as a defendant, one should be looking at the issue of sudden onset and looking at the medical backdrop to the case, it just is an interesting set of facts. So just to sort of pull together some of the principles that emerge from the various cases. The defence of sudden onset, as I said, arises where you get a set of papers and immediately it appears as if the defendant is banged to rights. But when you go behind it, there's something more. There is a medical condition there which has led to the accident. it may arise in a number of different types of scenarios. You may have a situation where there's an incapacity out of the blue. You may have a situation where there's prior signs or symptoms, or you may have a defendant with a pre-existing condition. So in an incapacity out of the blue situation, here the injury couldn't have been foreseen or avoided by any exercise of diligence or care on the part of the defendant. Nothing he or she could have done as a reasonable, prudent or diligent person would have avoided what happened. So in this type of case, the defence is straightforward. The defendant will have to prove that the onset of illness was sudden, without prodromata. It's a great word. It just simply means the warning signs or symptoms or prior warning. The defendant couldn't reasonably anticipate the occurrence and couldn't be expected to guard against it, and the resulting incapacity was such that the damage was unavoidable. Where you've prior signs or symptoms, this is a sudden onset of the incapacitating illness which has been preceded. This is a bit like our Mr. Parker. Signs or symptoms here, the possibility of the defence succeeding is not as clear-cut. So a defendant in this type of case will have to show that the defendant's failure to heed the prodromatal warning signs constituted the action of a reasonable and diligent person, and that will obviously in turn depend on the severity, the degree of severity of the symptoms, or the obvious character of the warning signs, as well as the capability of the individual to ascribe or to relate these as important and potentially dangerous. And the defendant will also have to show any warning was minimal, or like Mr. Charlton, that the ability of the defendant by reason of intelligence or the impairment, he couldn't recognise and realise the potential danger. And the final sort of set of cases that might arise is, as I say, where you have a defendant with a pre-existing condition. So you have an individual with a diagnosis, but that individual is under a competent clinician and is receiving adequate medical care, but experiences a sudden incapacity. Again, if you want to advance a sudden onset defence in those circumstances, you would have to show that the defendant was following the course that a reasonable, diligent and prudent individual would follow, and that the sudden episode occurred could not have been anticipated or further guarded against. So that's the conclusion of the formal presentation. I hope I haven't overshot the mark there, Lawrence.
No, not at all, Deirdre. It's excellent. It's a complicated subject with lots of sort of subtleties to it, and I think you've summarised it brilliantly in a relatively short period of time. So thank you very much for that. We have some time for some questions. If anybody would like to put a question on this subject, just unmic and fire away.
I'll jump in, Lawrence, if that's okay.
Yeah, hi Stuart. Yeah, please.
Hi, Deirdre. Stuart Cook, Admiral Insurance. That was really clear, so thank you. If you could just, if I may be so bold as to ask you to pop your slide back to the slide before. So
Sure.
Just forget the exact wording you used. No, the one before that, sorry, beg your pardon. Incapacity out of the blue. So when an insurance company has an accident that falls into that category, and I'm asking you the question because we do, there's different considerations for an insurer around running a defence of this type. Normally these sorts of cases, and you alluded to it in the talk, are quite emotive, and a judge has a heavy heart when he chooses to find there was no negligence on the part of the driver, no matter how much sympathy you might have for a driver. If people have suffered life-changing injuries, it's not a satisfactory situation. So I suppose the biggest consideration for us would be adverse publicity, media attention, and that potentially leading to a change in the law to impose strict liability. I just wonder if it's a bit of an abject question, but I think if insurers are running strong cases, the right cases, and succeeding, how likely do you think it is that the judiciary, with their heavy heart, might look to implement some sort of legal change how likely is that in your view? Because they would attract quite a lot of media attention, wouldn't it? The wrong sort of case or the right sort of case, depending on how you look at it.
Absolutely, because particularly if you look at a case like the Davy case that I spoke of, even the language used by the judges in that case, I think one of the judges in the Court of Appeal talked about Mr. Zakar being in control of a guided missile. It was a huge articulated truck. So there certainly would be a heavy heart, and I suppose the temptation would be to revert to the temptation, first of all, on the part of the judiciary would be to revert to a much more objective standard. So to impose, so in Ireland, to row back, firstly, from the sort of Mansfield type of dicta, and to impose a standard akin to that of automatism, so a total loss of control. I don't think beyond that the judiciary could go, and that is the way. That's exactly what in that Singapore. I don't have the reference now, but that's exactly what they did in Singapore. They rowed back, and they talked about public policy, and they effectively, I think there would be room in the case law to do that. So, for example, if you look at a learner driver, the case of a learner driver is one where the learner driver is held to the standard of a reasonable driver with no allowances made. So I think the judiciary could certainly push back against the Mansfield. Mansfield certainly seems to allow more scope legally, which is slightly different to your question, Stuart, which is how would it land? But Mansfield offers more scope for the defence to be argued legally. I think what all the judiciary could do would be to row back and to row back, but I don't think they could row back completely. I think that ultimately a change in the law, they would have to sort of sit on a change in the law as a matter for Parliament. I don't think they could roll it right back. And that really is a policy question, whether or not there is to be cover for whether we're into strict liability, and it gets to the heart of negligence.
One of the things we've been talking about was whether this is something that falls into the category that should be dealt with by the MIB.
Yes.
And that there may be a compensation fund that sits there which deals with no negligence rather than an imposition of strict liability.
Yes, but of course, but at the moment it just doesn't, and that's exactly what Clark sort of says in the Coonahan decision. He says clearly this is, you have the MIB is designed to pick up in circumstances where there should have been cover and there isn't cover. Here there's no negligence, but you have a seriously injured plaintiff. And he sort of flags that maybe that's an area that should be looked at as requiring expansion. But I don't think the judiciary on their own could push it back to that extent.
Yeah. Okay, thanks, Deirdre.
Other questions? Okay. All right. Well, just remains for me to thank you, Deirdre, very much for that talk. Thank you, everybody, for coming along. This was, as I mentioned, was the first Foyle Island Learning event of this year. And there will be lots of others. We're aiming to do one a month. And assuming you are registered and on our invitation list, which I guess is why you're here, and you will get invitations to all of our events coming up. So look forward to seeing you at the next one. And thanks once again for everybody's input and for your work, particularly Deirdre. Thank you. Oh, somebody's worked out how to do a round of applause on the sign there, so that was very good. I don't know if you saw that, but it was good.
Thank you.
Thanks, everybody.
Thanks
Thank you.
Bye.
Thank you.
Thank you.
Bye.
Thank you.